All right. Court of Appeal number 26, District of the State of Florida is now in session. The Honorable Chief Judge presiding. All persons having been before the court draw near to the attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. To be seated. All right, good morning. Thank you, Marshall Crawford. Welcome to this oral argument session of the 6th District Court of Appeal. I'm Judge Keith White and have the honor of serving as the presiding judge today. Serving with me today on my right is Judge Ganem, and on my left is Judge Lambert, who's graciously been helping us for almost a year now. I do want to remind you a couple of housekeeping matters. One, the proceedings here today are being both video and audio recorded. I just want to make you aware of that. And then also, please make sure phones or any other electronic devices that beep, vibrate, play music, or make other kind of noise that might disturb the proceedings, please make sure they are off. Thank you. All right. Our first case today is 2023-2617, Beacon Park Phase 1 Homeowners Association v. D.R. Horton, Inc., etc. Counsel ready to proceed? I believe. All right. All right. Whenever you're ready.
Good morning,
counsel. How much would you like to reserve? How much time for rebuttal?
5 minutes, please.
5 minutes. Okay.
Good morning, Your Honors. May it please the court. My name is Samuel Alexander, and I represent the appellant in this case, Beacon Park. This court should reverse and remand for two principal reasons. First, the trial court erred in ruling that Beacon Park had notice of defects in the 2011 new stucco before those defects even existed. Second, the trial court erred in ruling that the removal and replacement of an entire building component, the 2009 old stucco, and its replacement with a new building component, the 2009 new stucco, requiring new plans, new permits, and new approvals, was a repair to completed work within the scope of the prior permit.
Mr. Alexander, I'd like to go back to the beginning and look at paragraph 1 of your complaint. It reads that this is an action for damages arising from the negligent and defective development, design, construction, repair, and sale of condominiums and common elements at the Beacon Park Phase 1 community in Orlando, Florida, the townhomes. Just reading paragraph 1, which is incorporated by reference in all the causes of action. Why doesn't that tell us that for purposes of 9511, the relevant improvement upon which this action is founded is the townhomes, and that the work at issue here, the repair, is repair to completed work of the townhomes?
I think that there are two responses to that. The first is that there's a difference between a repair and kind of the common sense use of the word repair and repair in the statutory sense of the word repair. So For example, a new stucco installation or a new roof might be a repair to a building. But it's not a repair to the old roof, or it's not a repair to the old stucco installation. The second response is that the issues were narrowed considerably by the time that summary judgment occurred. And the trial court's judgment notes that the parties had, Beacon Park had conceded that it was only suing on the new stucco work by the time they got to summary judgment. There's all other issues had been resolved. So the only defects remaining were the defects contained in the 2011.
But when this case was filed in 2020, the safe harbor was in the statute of limitations, the repair safe harbor. And the language of the complaint talks about the action as being an action regarding all the townhomes, and uses that word repair and even defines the work that's at issue in this case in the complaint as, capital R repairs. Now I understand when we get to summary judgment, the owner calls this new work, but we haven't seen whatever stipulation is referred to by the parties. Was there some stipulation that it was not a repair, that it was new work?
No, there's not a stipulation that it wasn't a repair, but there's a stipulation that the suit only revolved around defects contained within the 2011 new stucco work. And I think there's a difference between the word repair as it's commonly used and repair as it's used in the term the statute for the purpose of the statute of limitations. And so it's kind of like the difference between, is a tomato a vegetable or a fruit? In common parlance, maybe it's a vegetable, but botanically it's a fruit. In this case, the repair may be a repair in common parlance, but under the statute, under the 2019 amendment, a repair is limited to when you have completed work that was built pursuant to a permit and a COO is issued, and you correct defects to that completed work and then sue on that completed work. The correction of defects does not extend the statute of limitations.
But didn't Beacon Park here sue on the completed work? I mean, that's what it says in paragraph 1 of the complaint. This is about the design, construction, planning, repair, and sale. It's all of it in this case.
Well, and there was an amended complaint.
Well, I was reading from the amendment.
Okay. But again, we would just reiterate, by the time it got to summary judgment, the suit solely revolved around defects within the 2011 new stucco work. And there was no repair to the 2009 old stucco work. It was completely removed. All the defects that existed. So they argued that there was notice of defects within the building envelope or the building writ large. But any defects that possibly existed within the 2009 old stucco were entirely removed and replaced by the 2011 new stucco, which contained new and different defects.
How do we know that from this record?
Because there is a stipulation below. The 2009 old stucco was entirely removed all the way down to the wood framing of the building. And so that the 2009 old stucco is what D.R. Horton told Beacon Park, hey, there's some performance issues with the stucco, we're going to replace it. To this day, we don't know what those issues were. Nobody in the record can say. But the old stucco was entirely removed down to the wood framing. The parties have stipulated to that. Mr. Alvelli, their corporate representative, testified that none of the 2009 old stucco remained. It was entirely reflashed from the ground up, or from the second story up with brand new stucco. So with new permits and new approvals. So it's really like a new roof. I think we can analogize it to a roof. If you replace your roof with a new roof and you strip the entire old roof off and you get new permits for a new roof and the old roof is stripped off down to the wood framing and there's new flashing and an entire new roof is put on, when does the statute of limitations start to run for defects contained within that new roof?
Wouldn't it make a difference if that new roof was put on to a recently completed project that's still, within a couple of years versus a new roof 20 years down the road when it's just being replaced because it's old and due for a replacement?
The statute doesn't make any sort of differentiation like that. So under D.R. Horton in the trial court's reading, a new roof on a building that's older than 10 years could simply never be sued on, because a new roof is just a repair to a completed structure that was built pursuant to permits and a COO is issued. And if you replace the roof, you're really just correcting a defect in the building envelope. And so it doesn't extend the statute of limitations from whenever the building was built, unless, as they say in their answer brief, unless the building is torn down. And we don't think that section 95.113.
Let me ask if we're talking about the new work, what is your summary judgment evidence in the record as to when those latent defects manifested?
So the only real evidence in the record are the two expert reports, the 2020 report and the 2021 report. 2020 report states that there was an expert that was hired to review the building. It reviewed the outside of the building. It didn't do any destructive testing and said, it looks to us like there are possibly issues with the stucco work. There's a lack of drainage.
And that report predates the filing of the lawsuit.
Yes.
The 2021 report, that would seem somewhat chronologically illogical that you became aware of the defects after you had filed suit.
Well, the 2021 report led to the amended complaint.
Okay, but all right, so your view then is the summary judgment evidence was that the statute of limitations began running at the time of the 2020 expert witness report, and then you therefore had 4 years from that date to file your action, which you did within a matter of months.
Yes.
What is the date? Well, let me rephrase it. Other than what appears to be what the trial court bought or agreed to, or whatever term you want to use, that the defects manifested themselves in 2011 when Horton came in and said, I'm going to give you guys all new stucco, or I'm going to replace the stucco, or whatever term. I mean, I know how we use those terms today is of importance. Is there any other evidence from their side as to when they believe, any other summary as to when they believe that the defect in the new work manifested?
No, they put all their eggs into the 2011 replacement basket, which is that they have two pieces of evidence that they rely on. One is that in 2011, they told Beacon Park there are performance issues with the old stucco, right, so we're going to replace it, if you don't mind. And the other is that the replacement itself acted as a form of open and obvious repair, giving notice of defects.
So if I understand their position, buttressed by the findings of the trial court, so in 2000, I think 2012 was when they say April 24, 2012 was when we finished everything in our remediation.
Mm-hmm.
So in their view, the meter started running, the statute of limitations meter started running in 2011 when they came to you.
Yes.
All right. And they came to you guys and said, hey, we need to fix this.
Mm-hmm.
So they would have, under their view, then you guys would have, Beacon would have needed to sue by sometime in 2015 on any defects to the new work, because the old work's gone.
Correct.
I mean, the old stucco's gone. Irrespective of whether there's anything at all that remotely showed to you that there was some problem with the new work.
Precisely.
That's the interpretation that I get from the final judgment that's entered adversely to you guys.
That's correct, yes.
And that's logically consistent with the statute, apparently.
No.
According to their side,
yes,
according to the trial judge.
We would disagree with that. We think that.
Well, yeah, I would think so.
We think that the statute doesn't intend for there to be the possibility of.
Well, I'm just trying to envision saying, okay, you know, they're Deacon's listening to Sam Alexander, and they say, we got to file suit. Horton gets the lawsuit, and they say, hey, what's the problem with the work we did? Nothing.
We don't know.
We have any defects. Well, why you sued us? Because the statute might run, and there might be something comes down the road. Is my logical question the proper extrapolation of the posture the case has placed you in?
Yes.
All right.
Counsel,
Sure.
you made you referred to the D.R. Horton's coming to Beacon Park in 2011 saying there's a performance issue with the stucco. We'd like to replace it if you don't mind. But Beacon Park wasn't, merely a passenger at that point. It was your townhomes. You could have said no. You could have said, why do you want to replace it? What's wrong with it? What are the defects that you're fixing? Now, the record doesn't show us whether or not any of that happened. But we also can see from the record that you have your expert report refers to ongoing water intrusion issues. It refers to the collection of surveys or questionnaires from homeowners. And if I go back to the trial court transcript from the hearing, the trial court judge, did understand your theory and said, so what you're saying is that there was a latent defect that didn't manifest in, for example, the trial court used 2016. And so you filed suit in 2020, so you were timely. And I understand you were personally weren't trial counsel, but trial counsel's response was, well, nobody knows. There's no evidence when we did discover there was a problem. So how can we sit here and have with any confidence and say there wasn't a discovery of whatever the defect was within 4 years of 2011 or 2012?
I think the response to that is twofold. First, below and on appeal until recently, there's been no question that the burden was on D.R. Horton to show that there was actual or constructive notice more than 4 years before the suit was filed. So Beacon Park asserted in its summary judgment response below that D.R. Horton had the burden of proof. D.R. Horton never pushed back against that. So the posture of the case was, well, we have this expert report from 2020, but no, we don't precisely know when these defects manifested. But it was D.R. Horton's burden to show that. There's been a question on appeal over who has the burden. We've got some responses to that if you'd like to hear them. But I think the other evidentiary fact that we have to rely on is the 2020 and 2021 reports themselves are evidence. We cited the value case from the 11th Circuit Court of Appeal, are evidence themselves that Beacon Park did not know that there were actionable defects or what caused the actionable defects, and that they were exercising due diligence.
Help me factually from the record to connect the existence of the reports and whatever those reports say, and when Beacon Park, knew or with the exercise of reasonable diligence should have known there was a problem.
So I think the 2020 report, there's not much indication, but the 2020 report doesn't. One thing that we do know is the 2020 report does not mention any water intrusion. It's the 2021 report that mentions water intrusion. So one thing that a jury could reasonably infer from that is that there was no water intrusion prior to 2021 because the 2020 report didn't mention it, and that Beacon Park didn't know about any possible defects until 2020, and that they were
What prompted the 2020 analysis?
There's actually no evidence in the record as to what prompted.
Beacon Park just said, hey, we're gonna have somebody look at stucco in 2020 and tell us what they think?
As far as we know, yes. Yeah.
Counsel, would you agree if it's your burden, that lack of evidence in the record would support them?
No, because we believe that we've met the burden by arguing in the summary judgment response that the 2020 and 2021 expert reports were evidence that they did not and should not have known of actionable defects.
Let me ask you about under the new summary judgment rule. This statute of limitations raised by Horton still affirmative defense. They still have to make a prima facie showing of that before you have any burden to put on counter summary judgment evidence. For example, plaintiff sues on a car accident and says, well, you hit me last year and I'm injured and I'm filing suit. Defendant raises a statute of limitations defense. You say, well, let's say it happened now, it's 2 years now. Okay. There's no prima facie showing that the statute of limitations defense would apply in that circumstance, and then you would not have the obligation to put on any counter evidence. And is there some analogy here if they're relying on the notice being to the 2011 defect, of which the defect is not what the basis of the claim is? They really haven't made a prima facie showing of the applicability of their statute of limitations defense, which did not require then you to come forward, despite the verbiage of the summary judgment rule now, with counter evidence to show when you may have discovered the defect with due diligence. I don't think I could probably repeat that.
That's correct.
Said,
yes, we agree completely, and especially since it's stipulated that the defects in this case were latent. And so there's not an argument that, well, the work was done in 2011, so that's a prima facie case that the statute of limitations started running because there's a stipulation the defects are latent.
Counsel, you are into your rebuttal time.
I'll reserve my time. Thank you.
Thanks. Counsel.
Judge White has just had a primer on working the clock today. We'll see how he does on the second set.
We will.
May it please the court. I'm Lindsay Lawton, and with Michael Brownlee, I represent D.R. Horton. This court should affirm based on the simple and correct analysis the trial court provided, and it should reject Beacon Park's effort to evade the straightforward analysis by creating a distinction between new work and old work that is directly contrary to the 2018 amendment to the statute of limitations. I'll start with the main analysis that applies to this case and then address Beacon Park's new work / old work argument. So the main analysis is that lawsuits based on construction defects are subject to a 4-year statute of limitations. There's an exception for latent defects, and when a lawsuit involves a latent defect, it must be brought within 4 years of the time the defect is discovered or should have been discovered with the exercise of due diligence.
Ms. Lawton, let me ask you, suppose we had a clean slate here and Beacon Park was happy with the construction of the townhomes. There were no issues other than D.R. Horton coming in and saying, there's a problem with the stucco, we'd like to fix it. And they do that. And then, a few years later, Beacon Park just sues D.R. Horton based solely on defects in that new stucco work. I mean, it's undisputed there was significant stucco work done. Could they have based a lawsuit just on that stucco work? And by doing that, fit it into 9511, it being that the stucco work itself being the improvement on which the action was founded, and avoid this repair issue altogether?
No, they couldn't, because the repair issue is central to the analysis. The concept of new work is foreign to the statute. Under the statute, repair work is indistinguishable from the original work. And if I understand your hypothetical correctly, then whatever D.R. Horton did would have been repair work. Are you suggesting that this would have been a situation where D.R. Horton did not tell them that there were performance issues?
I'm just trying to fit the statute to the situation, that we have. It is clear that this was significant work. Your colleague analogizes it to a new roof, for example. And it's just hard to fathom that coming in and replacing the entire second story envelope, for example, still ties into the original construction, as if whatever defect existed in 2009 when construction was completed wasn't completely ameliorated by this repair. So I'm just trying to understand if they could have avoided this problem that we're having between new work and old work and repair, if they'd have just sued on that new stucco work by itself, if we would still necessarily have to look at it in the broader context that it was repairs to completed work that was just completed 2 years before.
I understand. Yet, changing the allegations of the complaint to not refer to the original construction would not have made a difference, because the facts of the case will be the same, that the work being sued over was repair work. And I understand, there's some concern that this was a large scale project, but the statute does not distinguish between major repairs and minor repairs.
Let me then see if I understand this chronology then that you're espousing. So let me change the dates. So 2009, they do this work. Horton finishes their work. So 2 days before 4 years of their completion, they come in and they replace all the stucco. They take out the bad stucco and put in the new stucco, and everybody's happy. Beacon says, well, that's very nice of you all to do that. And Horton says, well, we're just good guys. So they do all that.
Mm-hmm.
So if I'm understanding what you're saying now, correct me if I'm wrong, because, they now have 2 days under my hypothetical to file suit about any defect that shows up post new work. Am I accurate in what you're saying?
I don't think that would be the case,
Why
because
not?
there would be a new event that occurred that gave notice of a latent defect.
Well, what's the new, but under your scenario, the new event is Horton, taking your scenario and my hypothetical, the new event is, instead of 2011, Horton came in 2013 and said, hey, bad stucco we put on all these buildings. We're going to take all the bad stucco off and put all good stucco in. We got it from new people. Good work, good job. We're putting the new stucco on, and you're gonna be good as new. And who as a homeowner, as a Beacon, would say, well, hey, that's awful nice of you. Thank you. And you go do that.
So you're saying there was the original remediation, and then there was another one a few years later in the hypothetical?
Just like here, it's 2009 to 2011. And you guys are saying, you guys, Beacon, are on notice as of 2011, there's a problem. Therefore, if I read the judge's order, you should have filed suit by 2015. You didn't, so you lose. Okay, so but in my scenario, taking you to the illogical extreme, you come in 2013, 2 days before the meter's running. The statute of limitations meter, for lack of a better term, lack of a better legal term. And you do all the work and you're done. You're done 2 days before the 4 years ran on the initial work. Basically, if I'm understanding consistent with the position here, they had 2 days to file suit so that they're not barred by the statute of limitations. If 2 months later, that stucco falls apart for whatever reason, latent defects, and it's gone. Isn't that just the same case you have here, except I've changed the bar as to when it happened? And that's what you say is the intent of the statute. The legislature said that's a perfectly fine thing to happen.
No, Your Honor, that is not our argument. Our argument is not that they had to file as soon as the repair work was done. Our argument is that the repair work put them on notice of a potential latent defect and required them to exercise due diligence. And therefore,
In those 2 days, in my 2 days.
No, they had 4 years from the discovery of a latent defect.
Well, but the latent defect. Okay. I won't use your time. Go ahead. I'm sorry. Go ahead.
And an important thing to remember is not just that the repair work did not start a new statute of limitations under the plain language of the 2018 amendment, but also that under any scenario, Beacon Park had the burden to present evidence of when it discovered the latent defects, because that is an exception to the statute of limitations.
And isn't their position, if I'm understanding your opponent, their position is we became aware of the latent defect in the new stucco in August in 2020 when we got the report. Is there anything that predates that says that they became aware of a problem? That's why they engaged somebody to do a report.
There's evidence that predates that shows that they knew or should have known of a latent defect. And that is the 2011 and 2012 work that showed there was a problem with the building envelope. And so, I'm sorry?
With the old work, right? So they took the old work down. So we're gonna.
Well,
I'm trying to, as an old trial judge, I'm sitting here saying, okay, I'm looking at a jury saying, okay, here's the statute of limitations factual, because they want this to be a factual dispute for the jury. The jury would all scratch their heads and say, well, but they took all the old stuff down and they think the new stuff's bad. And you're telling me as Horton that, no, you got to go back to the time we put the bad stuff in, even though you took it all out. And you guys need to rule in my favor, enter, statute of limitations. There's many times I've read jury instructions to juries. They look at, you have the dog gets the turn of their head like, what you talking about? And I'm seems like I'd be following the same turn of the head here on if I was instructing in this case like that.
well, the situation here is not that the original construction was taken down. There was an original construction and there was a repair to it.
Yeah,
to the envelope.
you didn't bulldoze the house down, but I mean, isn't there suit about the stucco? Isn't it?
It is about the stucco and sealants and other components of the building envelope. They talk about the stucco a
How they
lot.
sealed the stucco to the house.
Right, but all of that is a part of the building envelope that all works together as a system. And in 2011, Beacon Park was notified that there were performance issues with that system, the building envelope.
Was there record evidence that they were complaining to Horton about problems, or did Horton just proactively say, we're, countrywide, we're going to make these changes because this turned out to be bad stucco that we installed?
The record evidence is that DR Horton came to them and said, we are concerned about performance issues and we'd like to repair it for you. And they accepted that. And DR Horton went ahead and did it. And they sat silent for 8
They weren't
years after
complaining.
that.
In other words, they weren't complaining. They're saying, man, you guys just built this and all that, we're having problems. You got your side came, the Horton, not you, but the Horton came to them and said, hey,
That's right.
okay.
And then did the work, and Beacon Park sat silent for 8 years and has provided no explanation for why it suddenly in 2020 decided to do an inspection. So once you get to summary judgment, we filed a motion for summary judgment. We said the statute of limitations has run. And the only evidence everybody presented their evidence on the statute of limitations. And
Well,
the
is
only
it your
evidence,
burden? Whose burden to show that so I understand that, that they discovered or should have discovered this latent defect. So isn't it your burden to show when they should have discovered the latent? In other words, you guys should have discovered this well before 2016. And when you filed in 2020, you're too late. So I win. Isn't that Wasn't it your burden to show that they should have discovered it with due diligence before 2016, the 4 years?
It was our burden to show that the statute of limitations had run. And then under the Richardson case that was cited in the supplemental briefing order, they had the burden to come back and say, no, it was a latent defect. And here's when we discovered it or should have discovered
Did the
it.
first DCA shift their view about that in a later non-construction case?
They did not, Your Honor.
You sure?
Yes. That case is not about
Glass versus camera?
Glass versus Cameron.
Camera.
I thought you were referring to the Caudill case
I
cited.
don't care about that one. No,
You'll have to remind me about the glass.
well, it wasn't in the construction context, but they were talking about, it was in the medical malpractice context where you have to, you know, you may not know that you've been the victim of medical malpractice and you have 2 years to bring your claim when you discovered it or should have discovered it with the exercise of due diligence. I mean, if the defendant, doctor, hospital raises that, it's their burden, according to a later first DCA case, post Richardson, to basically say, you know, you plaintiff should have discovered this well before well before 2 years before you sued us. The plaintiff doesn't have the burden to affirmatively show why they weren't diligent. I mean, obviously, if there's summary judgment evidence that meets the threshold of prima facie, then the plaintiff puts on counter summary judgment. But it seems the first DCA, I will admit it's in the context of med mal, but it's the same theory of discovering the defect you knew or should have known. It's not like a car accident. You hit me. I know you hit me. This is the day it starts running. You as a doctor leave the sponge in my stomach. I don't know about that right away. Hope I wouldn't think, but maybe I do, but I don't, but it still is a grayer area and it's your burden as the doctor. I don't understand why. And it seems like you traveled under that until we interjected the Richardson case by order here. Isn't that fair?
Not exactly, Your Honor.
No, okay.
So there's a
I
lot,
must be reading the wrong.
there's a lot to respond to there. So as far as the glass case,
Go ahead.
it's, as you pointed out, it's a medical malpractice case. Every statute of limitations requires knew or should have known. And a lot of times it is the burden of the defendant to establish that fact. But under the statute that we have here, it is expressly stated as an exception when the latent defect was discovered or should have been discovered. So that would distinguish the glass case. Also, in the briefing, in the initial brief, I pointed out the lack of evidence on their side of when the latent defect was supposedly discovered.
Counsel, you assert that it was the D.R. Horton basically putting Beacon Park on notice that there is a defect in the envelope by fixing it for free, basically. And so it's your position, and as you put forward in your summary judgment paper, that you've established it is a latent defect, but they've been on notice of it since we began the repairs in 2011. What would Beacon Park then have to show in response to that to avoid your affirmative defense? Because you already identify it as a latent defect and already say they're on notice of it. They said, well, no, we weren't. We don't know anything about construction. We're lay homeowners and board members. So what else could they have shown to avoid your affirmative defense or at least create an issue of fact for the jury?
They could have shown what happened that caused them to ask for that inspection to begin with. And here, when we moved for summary judgment and we said the statute of limitations has run, we presented all the evidence that existed in the record on that point. And when you look at all that evidence, there is one fact that tells you what possibly could have led to them to ask for that inspection. And that is the 2011-2012 work. If there was something else, then the burden shifted to Beacon Park to tell the trial court what it was. And that's true regardless of who.
So in 2020, they decided that we need to hire somebody to look at defects that occurred in the stucco work that was removed and, taken to the dump or whatever happens to old stucco in 2011. And I would think that they would have engaged the new engineers or stucco people to say, look at the stuff that's now on here. How are we doing? We want to be proactive. We want to be diligent. We've read 95.113C. We want to make sure we do that.
So of course
I'm trying to understand what it is. I would seem if I'm an engineer or a stucco person, so why do you want me to tell you if the stucco that's gone was bad or was defective?
The inspection was of the repair work.
Sure, the new ones, the new
Right.
stuff, the brand new stuff.
Yes, and the reason given in the inspection report for the inspection was a history of performance issues, which is exactly the language that is used in the record regarding the notice that D.R. Horton provided in 2011 and 2012. It also refers to water intrusion, but again, Beacon Park never said when this water intrusion occurred. And the absence of evidence on this fact is dispositive regardless of who bears the burden, because we certainly made a prima facie case by saying statute of limitations has run, here's the evidence on the issue.
But they're saying now that we became aware of the latent defect in 2020 when we got the report. And that's when we believe the statute ran and that we acted with due diligence, and that's how we first found it. There was nothing that came up before that. Apparently, because there's nothing of the record, I'll grant you that. So we became aware of it at that time. Why is that not material evidence to defeat your argument that apparently your side's position is that the meter started running in 2011? Am I accurate with that? The statute of
Yes,
limitations.
or at the latest in 2012 at the end of
April 24, 2012, when we finished everything and we packed up all our stuff, Orton left the premises, did our work. Okay, so at that point, they had until April 24 of 2000, Beacon, in your view, till April 24 of 2016 to do something.
Yes. To conduct an inspection and exercise due diligence to bring a lawsuit if there was a ground for one.
Okay, and so if they did that and there was nothing there, or if nobody made any complaints, we got no problems, everybody's happy, what a wonderful bunch Horton is, they fixed everything for us proactively, we didn't even ask them.
Mhm.
And so we had no reason to file suit. I would think if I was a trial judge, I'd sit there and say, well, why did you sue? If there's nothing wrong with what they did. Just to protect ourselves in case something goes wrong down the road. And I think I would probably think that means that they would lose at that time.
That's
But now
correct.
but later on, but now they do find something in 2020, and that's, they say, this is when it first manifested itself. And so we've thrown the gauntlet down. We filed suit, and you guys come in, oh, no. It's your burden to show they should have, whatever is wrong in 2020, you should have been able to see it back before that if you had done anything, but you didn't. Therefore, we went into the statute of limitations. I mean, isn't that your case?
Our case is that you should have exercised due diligence to inspect whether there was a defect when they were on notice of performance issues. And the rest of the case is just going back to your point about, well, they're asserting that the 2020 inspection report is when we found out. Well, there's no affidavit in the record saying nothing happened between 2012 and 2020 to make us get this.
So the performance issues you're referring to is we did the work for you guys in 2009, ended in 2009, and we didn't do very good work. So we came back in 2011 to fix our bad work here. And so you guys should be on notice that when we come and do work for you guys, it might not be very good. And well, I know that's somewhat tongue in cheek, but I mean, what are they on notice of once you fix everything at your own proactive initiation and not their request?
They're on notice that there were performance issues with the building envelope. And what they're now suing over was a part of the building envelope. And if there's a reason that they decided to sue on this in 2020, besides they woke up one morning and asked for an inspection, they have the burden to tell us that. Remember, Judge, that the new summary judgment standard requires more than the slightest doubt about facts or the mere scintilla of evidence. You have to present your evidence as you would to a jury. And if your evidence does not establish your burden, then you lose. And that's what's going on here with Beacon Park.
If you want it from historical, I was on the panel that teed it up for the Supreme Court to change the rule. I was the guy who was the mover of that case, so you can thank me or condemn me for the summary judgment rule.
Well, thank you for this case. because
Yeah, I know.
under that
You know,
rule-
maybe you might not like how it's turning out with you here with me, but
Well, let me ask you this, if suppose that in 2011, D.R. Horton said, the problem with the stucco is that water is getting in through the stucco barrier itself and through the house wrap and getting into the wood framing and causing problems. So we're going to replace it, and you do that, or Horton does that. But after the repair, the stucco works fine, but it's the seal with the window around the windows and so there's water coming in there. In other words, by repairing one problem, create another one. Would we still be in the same place if that had happened here? Would anything change about your position with respect to 9511?
I think that would arguably be a new latent defect, but Beacon Park would have to come to us and say, water started leaking in around the windows on a certain date. And we exercise due diligence to inspect why that was happening. And that is what we're missing here. They have refused to tell us why they ordered that inspection. The only evidence in the record is performance issues, water intrusion on an unnamed date. That means there's no question for a jury, and this court should affirm.
Thank you.
Thanks.
You probably want me to go back to the 50 CA.
I just want to touch on a couple of points. Your Honor asked opposing counsel if the allegations had been limited to the new work, would that make any difference? And the answer was no, it wouldn't, because the new work was a repair. There's no difference between, there's no such thing as new work under the statute.
Counsel, what about the language in the statute 9511 that refers to correction of defects to completed work or repair of completed work? You've talked about how, repair might mean one thing in two different contexts, but isn't it, if there was a defect in the stucco and D.R. Horton replaced all of it, isn't that the correction of a defect under the language of the statute?
That's a part of the statute, but the other part of the statute is completed work. So I think that contemplates a situation where you have a 2009 old stucco, and let's say there's a leak, and they come back under the same permit, because the permit is part of the statute as well, and they repair something within that stucco. They patch it, or let's say it's a roof, they replace a shingle. No new permits are required. They've corrected a defect to that completed work. The completed work remains on the site. The permits are the same. It's a repair that does not extend the statute of limitations for latent defects within that completed work. But that's not the universe that we're in. The universe that we're in is that all the completed work was removed. The completed work no longer exists. It was entirely replaced with new work. And as you pointed out, the defects are, we have no idea what the 2009 defects were. We have no idea what the performance issues were.
Well, they're gone.
They're gone. And they did not say that there were performance issues with the building envelope. They said there were performance issues with the stucco. They removed all of the stucco.
But they replaced the entire envelope, didn't they?
They replaced the stucco portion of the envelope. There was a portion of the house that had, or the houses that had siding. So I think it's really akin to a new roof. And then the question becomes, if you replace a new roof, if you replace an old roof with a new roof down to the flashing, under what they've said today and what the trial court held, that is just a repair to a completed construction. And the installation of the new roof itself puts you on notice that there may be defects, problems in the building envelope. And so that means as soon as anybody gets a new roof, they better have it, inspected every 6 months for the possibility of latent defects, because once 4 years goes by, you're out of luck. And you better hope that your house isn't more than 10 years old, because by the time the new roof is installed, statute of repose is already run.
What if to take your analogy a little, maybe make it a little different, I think closer to this case, what if they replace half a roof?
I think the difference here is that, and that's a very good question. I think the difference here is that there are two different siding systems in the house, or in the houses. There was the stucco that covered the entire second story floor, and there was siding that covered the first floors. So they use completely different systems, completely different contractors. But I think it's more akin to what would happen if you had slate roof on your garage and you had shingles on your house, and you replaced all the shingles on your house pursuant to a permit and didn't touch the garage. We would argue that the statute of limitations would start running from the installation of that new roof, just like it starts running from the installation of the stucco in this case. On the burden of proof issue, if this court is considering a tipsy coachman affirmance, which we don't think that it should, because we believe we didn't have the burden and that we've met the burden. But if it is considering it, we think because the issue was not really factually litigated below about whether or not the evidence in 2020 was sufficient, we think the proper remedy would be for a remand to allow that issue to be litigated. We request this court to reverse and remand for further proceedings. Thank you.
Thank you.
Good arguments. Good job, Stan.
Yes. Well done.
Need to, don't get to the one. No, I'm good, thank you. Disinvite me after my meeting this morning. I said, I don't think I like that guy. He's talks too much in research. Great little fan, he's sending an email watching this or something.
Right, the next case on our docket this morning and the final case in our docket this morning is 2023-3607, State of Florida v. Herard. Apologize if I'm mispronouncing that. Counsel ready to proceed?
Yes, Your Honor.
Counsel? All right, go ahead. Oh, I'm sorry, counsel, you have 5 minutes for rebuttal sufficient?
Yes, Your Honor. 5 minutes would be sufficient. May it please the court. My name is Richard Pals. I represent appellant the state of Florida. The state's seeking reversal of the trial court's order granting the motion to dismiss. The trial court found that the statute was retroactive from the post-July amendments, and it's the state's position that they are not retroactive. This is under 2 points with the state. First is the express legislative intent of section 775-022 mandates prospective, substantive, or procedural criminal laws to be applied prospectively unless one of the 2 retroactive exceptions apply. And it's our position none of those 2 exceptions will apply here. First, if these amendments were meant to be prospective, the text would have said so. It would say the legislator, Your Honor.
But if they meant to be retroactive.
My mistake, Your Honor.
Okay.
That is correct. If this was meant to be retroactive, the actual post-July amendments would say so. They would essentially have said this law is meant to be retroactive. If that is absent, we are now controlled under subsection 3 of section 775-022, unless either subsections 4 or 5 apply. Neither applies here because under 4, this is not a reduction in penalty. This was a newly defined crime. And subsection 5 does not apply because this was not the creation of a new defense. Again, this was establishment of a new element that we had along with that crime. To touch
Counsel, why is it not the establishment of a new defense?
Your Honor, it's not the establishment of a new defense, while I would argue certainly the creation of a new element in arguing that the state cannot meet that element is a theory of defense that someone would advance at trial. It's not referred to as a defense, it is referred to specifically in the statute. It's denoted as an element of the offense. And if they meant to delineate it as a defense, same as subsection 5 of the post amendments, as well as subsection 3 of the pre-July amendments, they refer to what is an actual defense. And that is in cases of carrying a concealed firearm when the governor has mandated mandatory evacuations. That would be the creation of a new defense here. Defenses for purpose of retroactive application are something that's going to excuse criminal conduct or justify criminal conduct, such as in our stand your ground law justifies the use of deadly force or non-deadly force.
That's an affirmative defense.
That is an affirmative defense. That is correct, Your Honor. And then when we get into excusing,
why should we add the adjective affirmative in front of defense when the legislature has said any defense, not just an affirmative defense, but any defense?
well, Your Honor, if that is the case, then we would be rendering subsection 3, I would argue, meaningless. And that is something that we do not.
Subsection 3 of
the 775-022 statute, Your Honor, the same one that gives us the subsections for the exception of whether or not we apply criminal laws retroactively.
why would it render it meaningless?
Because it states that it is presumed, or if the legislator is not going to tell us it is retroactive, we will apply our criminal laws amendments to them prospectively. If we are arguing any time that an element has been changed in a crime, we've added an element or we have tinkered with the elements in terms of enacting a new statute or amending a statute, and we say that is the defense every time, then subsection 3 is not going to kick in
Let
at
me
this
make sure I
point.
understand. So in other words, are you basically saying if a defendant gets up in a criminal trial and says, ladies and gentlemen of the jury, they didn't prove their case, that would basically be a defense, and if we follow along with that, then that would be retroactively applied under subparagraph 5 of this statute, and it would render subparagraph 3 meaningless.
Precisely, Your Honor.
So that's what so
That
if
is-
you're saying I'm not guilty, my defense is I didn't do it. My defense is they can't prove it,
The state doesn't have enough evidence. There's a lack of investigation.
as opposed to
I
committed the robbery under duress. I committed the carrying concealed weapon under necessity. Somebody was coming in to kill my family, so I found a gun and I defended themselves.
Yes, Your
Or
Honor.
I use self-defense. I was here, they're coming at me. Yes, I killed the person, but I was defending myself because they would have killed me. Those are defenses.
Yes, Your Honor.
Those are instructed to the jury as defenses.
That is correct, Your Honor. Those would be instructed to the jury as defenses. And-
Counsel, if I understand your argument, you're saying that we have to read subsection 5, I guess in peri materia with subsection 3 to make them work together. And if 5 means that every time an element of a crime is amended or added or changed, that automatically adds a new defense, then we'd always be applying these defenses, prospectively.
Yes, Your Honor.
Getting back to Judge White's question, then kind of on what principle do we read any defense to be referring only to affirmative defenses or defenses that sort of excuse a crime as opposed to affecting the elements? I just want to make sure that that we do our diligence and respect the supremacy of text principle that the Supreme Court has validated. Is it simply because we have to read it with subsection 3? Are there any other principles involved here?
Your Honor, other principles, obviously, as the Florida Supreme Court has held in the Connage cases, Ham versus Portfolio, our later cases that we currently have mandating how we control statutory construction. While, of course, in peri materia, I think is very important with this. In peri materia is essentially taken along with conjunction against our canons against surplusage, our canons against meaningless, and our canons that statutes be read also harmoniously with each other. I think those are obviously major ones we have here. Typically at the onset of all this is we're going to apply criminal statutes as well. We're going to stick with what the express definitions are within the text of the statute. We're going to apply
Counsel,
what.
let me stop there. Let's talk about definitions.
Yes, Your Honor.
So a defense in Black's law is defined as a defendant's stated reason why the prosecutor has no valid case. Again, Black's law, legal defense. It's or general defense, a denial in broad terms of at least one element of the charge. So
Yes,
under the supremacy of text principles, how can we, instead of construing any defense as those definitions I just said, limiting it to an affirmative defense, which I agree, you've mentioned some of them, justifiable use of force, duress,
Yes, Your Honor.
things of that nature. Certainly those would also be included, but why should we limit them just to affirmative defense?
Again, Your Honor,
Given the language chosen by the legislature in making this policy decision.
certainly going into the plain and ordinary language, like you said, utilizing Black's Law Dictionary or utilizing Merriam, what have you. I see how saying a defense is, I would argue the legislator did not choose any theory of defense.
Well, it says any defense to a criminal statute, isn't it?
That's correct, Your Honor.
So just saying I'm not guilty, they haven't proved it. Is that, yeah, I mean, under the Black's Law Dictionary that Judge White's citing, yeah, I guess that's a defense, but it's a defense to a criminal statute here.
Yes, Your Honor. And to be clear, many times defenses are delineated within the statute themselves. They will say it is a defense. And, whether we're dealing with attempt, solicitation and the like, and going into abandonment, which they state later on in the chapter 777, Obviously, in this law, it expressly states when it is a defense, being when you are doing a mandatory evacuation. And even without a license, you will be, or without capability of being licensed because you are ineligible, you would still be allowed to carry the firearm when the governor has mandated the
I mean,
mandatory
a defense
evacuation.
to a crime, saying I'm not guilty, I didn't do it, that's. I don't
That
know, is a
anyone can
defense
say
to a
that, Your
Criminal
Honor.
statute, that's just a defense is they can't prove I'm guilty.
Your Honor, at this point, I would argue that we would be reading the phrase theory of defense into the language of the statute and essentially
Would we be
legislate.
would we be reading out to a criminal statute? Any defense to a criminal statute, I suppose, any defense, if it's any defense, yeah, I'm not guilty,
Yes, sure.
they didn't prove it, that's my defense.
To say any defense to a criminal statute and to read it as broadly as proposed here, everything will be retroactive at that point, I would argue. And
Well, counsel, I guess 2 points on that. One.
yes, Your Honor.
If the appellee in this case would already have been found guilty, adjudicated guilty, sentenced, and it's final, even under Section 5, they lose because the legislature has drawn a line, and that's finality, and as well as for the punishment as well, as long as the punishment has not already been imposed.
Your Honor, to clarify, you mean in under the defense theory, correct? Because I
That
know
is if-
that, because
right.
that technically will still, unlike the reduction in penalty, which goes until imposition of sentence, the creation of a new defense is applied retroactively, even while on appeal, until the judgment and sentence has been affirmed. That still technically will apply. So had the legislator, I
Right,
think,
once it's affirmed. When you say it will swallow that would swallow subsection 3, it won't swallow it if there is finality. That is, if there's no appeal, it's a final judgment and sentence, or if there is an appeal, it's been affirmed on appeal and it's final.
and for that, Your Honor, there's no prospective application of a statute when there's finality. We don't, after someone's been convicted and their conviction's been affirmed, post-conviction remedies have been exhausted, the state's not seeking further prosecution. The prospective application is for the present prosecutions. That is, along with subsection 3, it states this will not affect the prosecution. This will not affect the charging. Subsection 3 draws out 3 separate subsections under A, B, and C. We are painfully explaining, the legislator, I should say, is painfully explaining that current prosecutions, criminal law, be applied prospectively in all of them, unless, of course, we're meeting the subsection 4 or subsection 5, or this law itself states this will be retroactive. Of course, this law did not state that. When you go to chapter 2023-18, there is nothing within here under any provision that was enacted under that laws of Florida that asked for retroactive application.
Was the basis of the trial court's ruling below actually under subparagraph 4 of 775-822?
That is correct, Your Honor.
Basically said the penalty's been reduced from X number of years to 0 years.
There was no assertion, Your Honor, of subsection 5 in the motion to dismiss below.
Or in the order.
That is correct. Or in the order, the trial court did not make, of course, this court is entitled to de novo review of these things, but without any finding whatsoever on this, courts have held that we would not delve into tipsy coachman doctrine as it is, because this was not teed up by the defendant below. This was not teed up in
But
any.
what factual findings are missing by the trial court in this particular case? I understand there's some cases about not applying tipsy coachman if a factual finding is necessary, which was never made by the trial court. But here, my understanding, correct me if I'm wrong, counsel, is these facts are completely undisputed. It's purely a legal issue.
Your Honor, to a certain degree, yes, this is purely legal, and of course, the state is prepared, was prepared to respond to briefing in this in its reply brief when this was brought up for the first time in the answer brief, and of course, we're prepared here to argue it now. But it's my understanding that the state is here to reverse the trial court's order. The trial court's order was strictly about whether or not this was a reduction in penalty under subsection 4. The state wasn't able to really create any arguments below an order giving the judge perhaps a reason to deny the order.
That
under
wasn't
that
the
nature.
reason the defendant was arguing.
It was not the reason argued by the defendant. In this particular case, unlike the other 5 that are traveling together with it, the motion to dismiss is slightly tweaked in that it does assert one other option, and that is actually regarding the essential element of the offense, in arguing that because the statute should have been retroactive, the state needed to allege that both the defendant did not have the license and was ineligible for the license. I look at that particular, looking at that, the defendant has essentially conceded in my head that this was an element of the crime and not a defense. Otherwise, they wouldn't have argued this statute's retroactive and the state needs to allege this in the charging information, and thus this needs to be dismissed, which would fail on a motion to dismiss anyway, because we cited to the relevant statutory text, which gives the elements of the offense. But at the same time, the defense basically acknowledged that this was an element of the offense and not a new defense when it created its motion to dismiss.
If it's an element of defense, then you're saying, well, that's part of the definition of what this crime is.
That is correct, Your Honor. And I know I
And
was,
so if you look at, as Judge Lambert mentioned, criminal statute in this case, about as broad as the legislature could possibly make it,
yes, Your Honor.
dealing in any way with a crime or its punishment, and then give some examples, defining a crime or a defense to the crime. So distinguishing between a defense, which may be an affirmative defense,
Yes, Your
just
Honor.
to make sure it's covering it, also defining a crime. So if this statute allows the retroactive application of a defense to not defense to a crime, but defense to a criminal statute, which would include an amendment defining or redefining the crime, how does this not fall within the scope of Section 5? And I'll make it a two-parter.
Yes, Your Honor.
If there's some ambiguity, is the statute that the legislature has adopted in 775.021 sub 1, the rule of lenity, require that we construe that in the most favorable to the defendant?
Your Honor, to respond to your two-part question, first with the first question that you proposed, talking about defining a crime or a defense, that present participle phrase, defining a crime or a defense, that goes into the state's assertion that, again, when we are going through whether or not a statute's plain language says something, or whether it is plain and unambiguous, or it is ambiguous, we also apply, the traditional canons of construction, and that applies the negative implication canon. I know I already went through surplusage, meaningless, harmonious readings. That's the last canon that I did not employ yet. And by going into negative implication canon, as I pointed out in the briefs, defining a crime or defining an offense or defense, that is two separate members of that definition of what a criminal statute is. We've already said criminal statutes apply prospectively unless two of the exceptions under subsection 4 or subsection 5 apply. Subsection 4 is the punishment. In reduction in the punishment, criminal statute says it establishes what punishment will be. It states that it will define a crime. It states that it will define a defense. Negative implication canon shows that it would say the establishment of a crime, or the changing of a criminal elements, the amending of a crime, redefining a crime, however have you. By reading in that express definition of criminal statutes, the state did put this out in its brief, by talking about defenses, talking about sentences, but not talking about defining the crime itself. And this here is defining the crime. It is stating what criminal conduct is now. Based on the post-July amendments, citizens are authorized to carry as long as they are eligible for licensure. The crime is to not be eligible for licensure now, carrying a firearm when non-citizen, under 21, or as a felon. So it's the state's position, Your Honor, that going under subsection 2 plays into the state's assertion that the express legislative intent of subsection 3 is not defeated on these post-July amendments by subsection 5, the establishment of a defense.
You run out of time.
I see that I am eating into my rebuttal time here, Your Honors. I'll reserve the rest of my time for rebuttal unless this court has any other questions at the moment.
All right, thank you.
Thank you, Your Honors.
Yes, Your Honor. May it please the court. My name is Joshua Sinclair and I represent the appellee Naya Herard. Trial court order should be affirmed because the changes and amendments to the carrying concealed statute, Florida statute 790.01, apply retroactively under Florida statute 775.022 under subsection.
Was the basis of the trial court's order, the subparagraph 4 of 775.022, that it was the reenactment of the statute reduced the penalty?
Yes, Your
Is
Honor.
that the sole basis for the ruling?
Your Honor,
Basically?
I would say that was not the sole basis. This was filed as a C4 motion. The facts were not disputed. The trial court did only discuss 775.0224. However, the trial court specifically stated that the appellee did not commit an offense under the new statute. And I
Well, she
believe
did.
that,
Right, and I mean, if she would have done this July 10 of 2023, then she wouldn't have committed a crime. Right?
that's correct, Your
Okay,
Honor.
but the problem is she didn't do it before, but she did it before that.
Right, yes, Your Honor. And although the trial court did not specifically refer to subsection 5, trial court's finding that she did not commit a crime, that language can be used to show that she's putting forth the defense that she would not have been ineligible to have a permit.
Well, I'm looking at the order. I mean, it goes on. I mean, every page of the order, it looks like, talks about subsection 4. And it talks about the Dean case from the 5th DCA, which isn't that a fairly distinguishable case from the present?
No, Your Honor, I wouldn't. It's distinguishable in the sense that the Dean case,
Watch, I wasn't on that panel, wasn't I, before I started saying anything about it? Go ahead.
the Dean case is distinguishable in the sense that it dealt with stripping the court of jurisdiction because it went from a felony to a misdemeanor.
Well, because the penalty check, I mean, because the elements changed. I mean, it went from $400, what was alleged in that case was stolen, was no longer a felony.
That's correct.
And
Your
so the penalty changed. I mean, the elements of the crime didn't change, the penalty changed. And so in Dean, we basically said, you no longer have jurisdiction circuit court because the statute subparagraph 4 of 775.022 comes into play and it makes it a county court case, right?
Yes, Your Honor, although I would disagree that the elements didn't change. The element for grand theft changed from $300 to $750. So there was a change in elements within the theft statute. And that's very similar to what we have here in that the elements have changed for what constitutes criminal carrying of a concealed firearm. And in that manner, that these cases are not distinguishable.
All right.
Counsel, it's supposed that we wanted to focus on subsection 5. As I read this statute, it says this section may not be construed to limit the retroactive effect of any defense to a criminal statute enacted or amended by the legislature. Doesn't subsection 5 deal only with defenses that are enacted by the legislature or amended by the legislature as a matter of statute, as opposed to you didn't establish an element of the offense, which is not a statutory defense. It's just sort of a theory of defense.
No, Your Honor, I do not believe that's the case. It specifically says limit the retroactive defense of any defense to a criminal statute. Had the legislature meant affirmative defenses, they would have put affirmative defenses, but any defense would be negation of an element is a defense to any criminal statute.
But the statute doesn't stop at any defense to a criminal statute. It says any defense to a criminal statute enacted or amended by the legislature. Doesn't there have to be an enactment or an amendment of a defense in order for subsection 5 to apply?
No, Your Honor, the way I read it is it's any defense to a criminal statute enacted or amended by the legislature. So read it as two separate parts. You can't limit the retroactive effect of any defense. Second part is to a criminal statute enacted or amended by the legislature.
Does that make the most sense though? Because a criminal statute is necessarily something done by the legislature. To add the modifier enacted or amended by the legislature, it only makes sense to me if it's talking about a defense. A statute is necessarily a creation of the legislature.
Yes, Your Honor, this subsection 5 needs to explain the mandate that this entire section or the 775.022 not be construed to limit the retroactive offense. That's a mandate from the legislature. The fact that they wrote enacted or amended by the legislature in a criminal case, I don't believe there's surplus in there because they're talking about a statute when it's enacted or amended rather than repealed. So if the statute was repealed, I think we'd be in a different situation. And so they're narrowing it to just enacted or amended rather than repealed or anything else that legislature may
Well,
do.
let me ask them. I mean, I'm trying to think of the hypothetical. If you saw the last thing, we have a lot of hypotheticals, so these come out of my mouth. All right, so if I'm looking at the statute, it's subsection 3 of 775.022. If the statute stopped there, no force, no subparagraph 4, no subparagraph 5, you would lose.
That's correct.
Okay.
Yes.
All right. Then for the purpose of this discussion, let's assume you're not going to win on your discussion on subparagraph 4.
Yes.
Okay, so now the focus is on number 5. And so what I'm trying to gather here is the position that you're saying is a defense is defense. I'm not guilty. You didn't prove it. So give me a scenario where it seems to me that's completely surplusage because you're always going to have as a defense, I didn't do it, or I didn't do it. I'm not guilty. Now, my defense is I'm not guilty. My defense is the state didn't prove their case. I don't put on any evidence. I get up and said, well, ladies and gentlemen, jury, they had to prove all 3 elements. They didn't prove number 3. They didn't prove their case. Have a nice day. Please find me not guilty. So that's a defense. Under your scenario, because it's a defense, it applies retroactively because the statute of which your client is charged was amended. That would seem to apply to every time the criminal statute is amended. Or give me an example where it wouldn't. Maybe that'll help me work this in my head.
So an example would be if the elements are not changed at all and just the penalty. If we,
Okay, well, then we would be at number 4.
right,
Right.
but I'm
okay.
saying in that case, number 5 would not apply.
Right. No, I agree. Yeah. If you had number 4, if the statute we're talking about today, if the legislature said, and if you commit this crime, it's now a 2nd-degree misdemeanor as opposed to a 3rd-degree felony as of July 1, 2020, then you'd say, Dean, look at Dean. It's a misdemeanor. I mean, or you'd say I'm not guilty at all, but let's say they didn't change the elements, but yeah.
Another situation, Your Honor, would be if the legislature added removed an element, then it wouldn't apply retrospectively. It would only apply prospectively. And there are ex post facto issues there too, but the legislature is aware of that. And in drafting this, they clearly didn't want to violate ex post facto laws. I think another example would be with possession when back when the legislature amended it to change possession from lack of knowledge of the illicit substance from an element to an affirmative defense. I think in this situation, because of the ex post facto principles, this statute, I guess, would apply, but ex post facto would knock it out. But the way the statute is written is it's to give the defendants as much benefit, retroactive application, if they haven't been sentenced and their case isn't finalized, but they don't want to run afoul of the ex post facto laws. Because without subsection 3, ex post facto would be violated, would be violated if all criminal statutes applied prospectively.
Okay. Well, I agree with you, but go ahead.
Counsel, can you, when we're talking about affirmative defenses like justifiable use of force or insanity or entrapment, whatever the case may be, can you think of any examples where a defense, meaning something that avoids a crime, not just negating an element, but actual affirmative defense is not provided by statute? Or to flip that around, is there an example of a statutory defense that would not also be an affirmative defense?
Self-defense.
Yes, self-defense, Your Honor. Cannot think of any other ones. And just so I understand your question, is Your Honor asking an affirmative defense that is not provided by statute, or any defense provided by statute is automatically an affirmative defense?
I'm asking, is there any, can you think of an example of a statutory defense that is not also an affirmative defense?
Self-defense, Your Honor. I cannot think of any other statutory defenses other than the argument that when the burden of proof is placed on the state, negation of that element is a defense, and arguably that is a statutory creation of defense.
When I look at the prior version of the concealed carry statute, there's a Florida Supreme Court case from 2013, Mackey v. State. And there, when it used to be subsection 3, it said, it's not a crime to carry the concealed weapon if you've got a license. And the Florida Supreme Court said that is an affirmative defense. So, before the statute changed, having a license was an affirmative defense, according to the Florida Supreme Court. Now, having a license is up in the elements. Doesn't that sort of statutory change, based on how the Supreme Court used to interpret it, tell us that, it's no longer a defense to say I have a license. It is now, part of the crime. It took the, something that used to be in the nature of a defense and made it no longer in the nature of a defense. In other words, now the Florida Supreme Court wouldn't say that it's an affirmative defense. And I don't know how we could say that it's any kind of defense at all when it's specifically identified as an element of the crime. Am I missing something there with that statutory change?
Your Honor, by adding an element, the legislature has necessarily created a defense. So if having a license means you can't be found guilty of the crime, that is an absolute defense that you can raise, that the state has not proved that. The same thing with whether you would otherwise be ineligible. So the creation of an element necessarily adds a defense to any crime.
So you're basically saying if you add an element to the crime, you've added a defense because your defense is you haven't proved the new element of the crime.
Yes, Your Honor, that's correct.
Somewhat circuitous, right?
I don't believe.
And therefore it's retroactive.
Yes, when an
That's your argument. I mean, I know that wasn't discussed below basically, but that's the argument that is going to be the carrying the day one way or another, because I don't think you're going to win on number 4. It's up here at 4.
Yes, Your Honor.
But
And it is, yes, I mean, as
because we create an element and we statutorily says this is an element you have to prove to the state. Your position is that because you create an element by the amendment, you have created a defense, and my defense is you haven't proved the element, and therefore it is retroactively applied, even though it is a new element that the state has the burden of proving. That seems to be what you're saying to us in justifying an affirmance, probably for reasons unrelated why the trial court ruled.
yes, Your Honor, that is correct.
Fair enough.
Counsel, do you think that as part of our statutory interpretation, we have to consider the context of the amendment?
Yes, Your Honor.
And so in terms of the context, I mean, this statute 775.022 was enacted by the legislature in response to the amendment to the Constitution, correct?
That's correct.
And previously, the legislature was prohibited in retroactively applying either an amendment or reenactment or enactment by the Constitution.
That's correct.
Now that has been amended, so the legislature is only prohibited in retroactively applying a repeat. Is that correct?
That's correct.
And so now the legislature has the ability, although not the obligation. You agree, this is not, the case law indicates that the legislature may decide to provide retroactive relief to criminal defendants, but they're not required to.
I agree.
And so they've chosen to do that under the terms of 775.022.
I would agree with that.
And so guess your argument is, one, the statute, by its plain language, would allow a more favorable, amendment to from the defendant's perspective with respect to punishment, provided the defendant has not already been sentenced.
That's correct.
So there's a limit to sort of the legislative grace.
Yes,
And that
sir.
is, we're not going to undo things that have been final.
That's correct.
And seems even the state agrees that if it's affirmative defense, the legislature has exercised that same grace. And that affirmative defense could be a defense where the defendant has a burden of production. And if he meets the burden of production, it shifts to the state to prove beyond a reasonable doubt defenses like that, correct?
Correct.
Or the legislature could create an affirmative defense with an actual burden of proof on the defense.
Correct.
But again, provided the judgment and sentence wasn't final, that could apply retroactively.
Yes, that's correct.
Well, they could have contextually just said, okay, we see the constitutional amendment, except for everybody who's already been sentenced, because we're not going to do, 50 years of penalties. We're just going to say everything's retroactive from the get-go, because that's the will of the people now. But they chose not to do that in the context of amending the statute shortly after the Constitution was amended.
Correct. It seems like their concern was running afoul of the ex post facto clause. Had they done that, then this statute would be unconstitutional because it would run afoul of ex post facto. Are there any other questions?
No further question.
No.
All right, thank you very much.
Thank you, Your Honor.
Counsel. So to sort of follow up to my questions to opposing counsel before you came up. Would you agree that if it's a favorable amendment in terms of punishment, or a favorable amendment in terms of an affirmative defense, then those would apply retroactively?
Your Honor, that is yes, in the text of both subsections 4 and 5.
But if it's a change in a statutory element, which actually is more favorable to the defendant because it puts the burden on the state from the get-go to prove that a crime was actually committed, that doesn't apply retroactively.
That is correct. That does not apply retroactively, Your
So
Honor.
if this eligibility of a license was created as an affirmative defense in the statute, it would apply retroactively, but because the legislature has made it more onerous for the state to go against the citizen, that doesn't apply retroactively.
Yes,
That's the way we have to read the statute.
well, yes, Your Honor. I mean, because they have redefined the elements, it does not apply retroactively. I understand it's the same application as how you pose it, Your Honor, but it does not apply retroactively because this had to do with defining the crime or redefining the crime.
So it's the form of the amendment that controls. If they put it as an affirmative defense and call it an affirmative defense, it's retroactively, but if they put it where the burden never leaves the state at all, but it's a brand new element, doesn't apply.
That is correct, Your Honor. I believe you are speaking about abatement at that point. We're saying that we've made this more favorable to the defense, and that is decried under the first subsection of 775-022. We essentially supersede any common law concept of abatement here.
Sure.
When we decriminalize something, and here it is decriminalized. The original law states that if you carry without a license, you have committed a third-degree felony. Here we state you are authorized to carry without a license if you are eligible. It is a violation if you carry without that particular license at this point. So here we have, again, as I stated before, we're dealing with defining the crime, and we're not dealing with a new defense. And again, on top of abatement, the statutory express intent that we have within here I know that I am eating in my time, so of course, Your Honor, if you'd like me to wrap up, please let me know.
With our questions, I'll give you a little bit of time just to wrap up.
No, it's appreciated. I think, Your Honor was questioning the defense about the concept of it saying amended by or enacted by the statute. And I think that that plays into how we know that a defense has to be created by the statute in order to say that we are going to apply a defense retroactively under subsection 5 based on the text they have there, and how we don't run afoul of the defining crime definition of criminal statutes under subsection 2, the express legislative intent of subsections 3, as well as abatement under subsection 1. And on top, I believe I don't need to address Dean. This court seems to have a very strong concept of how that is inapplicable here. But here with this stating any defense is anytime I say I didn't do it or they didn't meet an element, I believe that's eating into the statutory language here, and that fails in the face of the negative implication canon as stated in the state's brief. If this court doesn't have any other questions, I will rely on my briefs, and I ask that you reverse this case as well as the 5 cases traveling together with it.
All right, thank you.
Thank you, Your Honor.
Thanks to both counsels. Well argued. All right, we will be in recess. Thank you.